Welcome back, viewers. We've been talking about transport accident legislation in Victoria, and in particular, the use of in respect of transport accidents. And Don, we've been talking about the case of Koutsoulis.
That's correct. This is Miss Koutsoulis whose arm was caught in a bus door. In that case, it was heard before Justice Kay of the Supreme Court, where it was held that incident was not a transport accident.
How's that possible, Don?
Well, he defined on what he thought was driving, and he said driving must be a feature or element of driving and must consist of the propulsion or movement of the vehicle.
And because he hit the button by mistake,
That's right.
that wasn't a necessary step in him driving. Is that right?
That's correct. So
Geez, that's splitting hairs, isn't it?
So
Well,
this is the button to close the doors.
That's right.
And he's hit the button to close what he thought was the front door of the bus, but in actual fact, he's closed. He's
closed the back door, and he was supposed to close the back door, but he closed the front door.
Well, you can see why he hit the wrong door. We
It
can't
must
even
be-
work. We can't even work out which
And
door it
Mrs.
was.
and Mrs. Koutsoulis has had her arm jammed in the door.
That's correct.
And but wait a minute.
No,
Why
no,
is it-
John. She's got a problem with her shoulder, her neck.
Yeah.
But nothing
No, but
serious.
the arm was
They're all-
actually closed. The door closed on her arm.
Did it?
Yes.
It's all musculoligamentus that won't amount to a serious injury.
The bus was on. It wasn't.
The engine was on.
The engine
Yes,
was
it was
on.
Stopped at a
And so
designated stop.
How has the judge said this is not a transport accident?
Well, if I put this in the pipeworks here, the bus cannot move until the doors are closed.
All right.
Now,
All right.
the reason why, I suspect if Miss Koutsoulis was running to the bus and the bus was about to move and the door's closing and she caught her arm,
You can imagine a lot of
Should've lost
serious
it.
accidents
That's right.
happening in those circumstances.
but in this case it's because the bus driver did not intend to move.
All
He was
right.
not taking the steps to move the bus.
And he's
There was
accidentally accidentally pressed
Can
the
you
button.
believe she's got
negligently.
rights because of his muck-up?
Yes, it's a very unusual
how
case.
bizarre is that?
Well, it is.
And if I recall correctly, the judge actually says in his reasoning, this case turns on the particular and peculiar circumstances of this case.
Don, give me
right.
other examples that would be use of in these sort of circumstances, because
Well,
I
look-
can't think of too many.
There is one unsettled law at the moment, where I've got claims which are accepted, where people are stuck in train doors, where the train's actually not moving. The train is stationary at the end of the line, and they can be stationary for 10 minutes. And with these new metro trains, train doors close automatically
you.
if they're open to save energy, to save efficiency with the air conditioners. And at the moment, to date, TAC have been accepting these claims as a transport accident.
And what do you say it's unsettled law? Is that on appeal, is it?
Well, at the moment, I'm not sure of the TSC's view now in light of the Koutsoulis case, bearing in mind Koutsoulis has just recently handed down.
That's a
So
very
it
recent
is,
decision.
I've had claims where they're accepted in those circumstances, which in my view, and in light of Koutsoulis, it should not be accepted.
Really?
It should be access for use of.
So are they examples of people that just wanted no-fault benefits?
Well, there's an example of people who will get no fault benefits because the claim's accepted, but we want access to the
Koutsoulis
Commonwealth.
wanted to get under Section 94 use of provision
That's
so
right.
she can sue for
That's
negligence.
Right. That's right.
She wanted to sue the bus driver.
So she'll get access to damages, pain and suffering, loss of income, medical expenses, without any thresholds to satisfy.
And John, the reason why she wants use of is that if she had to rely on the usual test, she'd need a serious injury.
She
wouldn't
won't satisfy the threshold unless she has a serious injury.
Which is what? Serious injury.
Either serious consequences of the injury or 30% impairment under the AMA guides. On this case, it didn't look like that was going to occur, did
Is
it?
there any other examples you can think of use of?
Look, use of cases would be walking up steps or down steps of the bus, tram, where there's maybe a jagged edge and they catch the leg and get
Oh, okay,
cuts
so
and-
it's something defective on the actual tram or train or bus.
That's right. There has to
Okay.
be negligent use of the motor vehicle, where I think in those circumstances, if there is a jagged edge on the steps and it causes injury, that's negligent
And
use
the
of
motor vehicle is not moving.
motor vehicle's not moving.
What if the bus driver in this case hit the right button?
I think the bus driver, well, there wouldn't be any injury. She wouldn't have sustained all her injuries.
What,
But I
if, what if
think
you hit the button at both doors?
I think that could be still negligent. But I think in
It
this
wouldn't
case,
be,
if
it
it
wouldn't
was...
be use of anymore, would it? Because it would have
No.
been him taking steps to
It's a
drive the
transport
vehicle.
That's right. If he was taking the steps undertaken to prepare the vehicle to move, and she was injured, then that will fall under the transport accident, according to Justice Kay's view,
Okay. Okay.
in my interpretation. But
Tony,
it's
The
done-
beauty of this provision is that you don't have to have a significant injury under the Wrongs Act, which is more than 5%. You don't need a serious injury under the Transport Accident Act.
That's right.
So you just, as we knew the law back
Many years
pre
ago.
1st of January 1986.
87, because it was the Transport Accident Act was introduced on the
1st of January 1987.
Before that, there was no serious injury
There was no
threshold.
thresholds.
No.
Yeah,
No.
yeah.
Tony, there's the case of Iacone, which is
All right.
very interesting.
So that we don't confuse the viewers, we're getting off the subject of use now.
Exactly.
Section 94. Now we're going back to usual transport
transport
accidents.
Transport accident. So now we're saying what is a transport accident, and according to
What's
the
a
Act-
Iacone, Don?
Well, Iacone case, it's an
good
interesting one where it was settled many years ago. It was Mr. Iacone was in his house and he hears an accident happen in front of his house, and Mr. Iacone decides to walk and have a look, as you do, and happens to walk over glass.
Hey,
that's
Don, can I
come
stop
from
you
one of
for
the
a minute?
vehicles.
When we were kids, remember you'd hear the fire brigade, the fire engine, and you'd try and chase it to see what a fire was.
Yeah.
Is that what Mr.
Oh,
Iacone
I
was
think
doing?
so. I think so.
But why has he gone out of his house barefoot to a transport
Well, he went
accident? It seems
barefooted.
a bit odd anyway, but go on.
So he walks over, happens to unfortunately walk over some broken glass that's come from the vehicle. And Mr. Iacone is a diabetic, and unfortunately, as a result of that cut, he
Suffered complications.
complications, and he lost his leg.
So he's
Pretty
cut
drastic.
his leg on glass from the transport accident, and the leg's been amputated.
Yes.
The leg was amputated.
John diabetes.
It was diabetic.
Complications.
Yes, oh yes. But wait a minute, what entitlement does he have under the Transport Accident Act?
Well, the question is whether his injuries were caused directly from the driving of a motor vehicle.
And you'd think, not really, wouldn't you? You'd think,
Well, the
how
glass was due to, there was an accident, and the glass was on the ground because of that. And the court said that that was in the driving of a vehicle, John.
Well, the court says there's got to be a causal connection, not just mere temporal, between the driving and the incident that's occurred. So in that case, if you break it down, there was an incident. It was a single vehicle accident, by the way, which ran into a tree, glass on the floor, not too remote for someone to come to render assistance or
So
have a bit of a look.
the causal connection in this case is Mr. Iacone walking to the transport accident, cutting himself on the glass which arose out of the transport accident.
That's right.
And thereafter losing his leg as a result of walking
What
onto
benefit? What did he get out of this? Did he get no fault benefits? And
Yeah,
did he
so
sue?
in those circumstances, a transport accident, so he would have been entitled to receive the no-fault benefits.
medical expenses.
medical expenses, weekly
Wages.
payments, loss of earning capacity,
Could he
Tony.
sue for
Payment
negligence?
benefits. And he could sue for negligence.
Why?
Well, it'd be the negligence of the driver who lost control
Slammed
of his
into a
vehicle and
tree.
slammed into a tree. Reasonably foreseeable that could
However-
happen.
That's bizarre, isn't it?
Wouldn't defence would anyway? There's
We're going to have to take this up another time.
Yes, Tony.
Don, thanks for coming on board again.
No, thank
Thank
you for
you,
having me.
appreciate
Thank
it.
you, viewers.
Thank you,
Viewers,
Tony.
stay tuned. We're going to go to a sponsors break and then Kathy's mailbag just after the break. Thank you.